Good afternoon, everyone. My name is Leo Lane, and I sit on the Law Society's Continuing Professional Development Committee. We are here this afternoon because last fall, the Federation of Law Societies amended its Model Code of Conduct by significantly expanding the chapter on discrimination and harassment. This spring, the executive of the Law Society of Yukon completed its review of the changes to the Model Code and announced to the membership that the executive is going to be holding a vote within the executive to incorporate the changes into the Yukon's own code of conduct. The executive's vote will be held on July 24th. And between now and then, all members are welcome to submit comments or concerns to the executive for their consideration. Today, to help us walk through the amendments and let us know how these changes might affect the practice of law here in the Yukon, I am pleased to introduce two speakers, Birju Dattani and Lesley McCullough. Birju moved to the Yukon in the fall of 2020 to become the new director of the Yukon Human Rights Commission, and from pretty much right away has been a tremendous resource to the Law Society on discrimination and harassment issues. He has presented for us in the past, and we're lucky to have him again today. Birju is a lawyer by trade. He attended law school in the UK and taught for a time at the University of London. Before coming north, he was an assistant regional director with the Alberta Human Rights Commission. Lesley McCullough has been practicing law here for many years. For most of her career, she was counsel with the Yukon territorial government, where she negotiated Aboriginal land claims agreements and served as the Director of Intergovernmental Affairs and as the Deputy Minister of Justice. Lesley also served as the Acting Director of the Yukon Human Rights Commission, and currently she is operating a public legal clinic offering advice to persons in the Yukon dealing with workplace sexual harassment issues. Just before I turn things over to our panelists, a couple of comments. If you have any questions or comments as we go along during the presentation, you are welcome to submit those through the Q&A or chat buttons at the bottom of your Zoom window. The speakers should see them pop up and respond as we go, or if you prefer, we're also planning to leave time at the end for a Q&A session, so you can wait until then and submit your questions, and I'll come back on screen and moderate that if we have any questions for follow-up. So thank you all for joining us on this beautiful sunny day. We are scheduled to run until 1:30 p.m. and the session is being recorded and will be posted on the Law Society's website afterwards. If you're not able to be here for the whole thing, or if you have colleagues that are interested and can't make it today, feel free to direct them to our website. So please join me in welcoming Birju Dattani and Lesley McCullough. Thank you.
Thank you so much for that introduction, Leo. Really excited to be here this afternoon with all of you to discuss the FLSE's draft, no longer draft code, I suppose. Model Professional Code is what it's going by on the website. So I'm going to speak to you all for the first two topics, which you'll find at section 6.3 of the code, which is discrimination and harassment. Lesley will then go over the final sections 3 and section 4, so the final 2 out of 4 items that we're going to be discussing. And I'm going to do a screen share in a moment. And again, thank you all for joining us. And Lesley and I both want this to be a discussion and a productive one, rather than us talking at you about some high-level concepts which might cause your eyes to glaze over. So if you have any questions, please throw them in the chat. Please don't hesitate about interrupting me as I speak. And we're hoping that this will be an exciting, interesting, and fruitful discussion about the code. So I'm just going to do a screen share here. Bear with me for a moment. So hopefully you can all see that. If it's glitching out, Leo, just let me know, but hopefully you can see the screen in front of me.
I can see it. The font is a little bit small. Are you able to zoom in at all?
How's that?
Yeah, that's great. Thank you.
Okay. Comes without surprise, but there are certain sections which are heavy with commentary. It's what happens when you get lawyers to draft things. And so I think the font is, you're right, Leo, very, very small, but hopefully you can see that now. And again, pop something in the chat for me if any of you are having difficulties with seeing this or hearing me, or if there are any tech issues, and we will certainly try to address that. And so for a little bit of context, my background is in human rights law. And so a lot of these concepts derive from human rights law, are interpreted through human rights law. In some cases, of course, they also are interpreted by other types of law. So for example, occupational health and safety legislation can be brought to bear on how to understand these concepts, as well as other bodies of law. So just as a bit of a caveat, almost everything that I'm going to be speaking to you about today is informed by how human rights legislation, together with the case law, has interpreted these concepts. So I don't presume for this to be a all-encompassing and final and rigid definition, conceptual discussion about what we're discussing. And so, of course, your own understandings in the various areas of law that you practice might inform this, but just as a bit of a heads up, a lot of these concepts do come from human rights law, and that's what I'll be saying to help all of us better understand these concepts. So at 6.31, 6.3, I should say, we have discrimination and harassment. And as I'm scrolling, I hope that it doesn't take too long to catch up with the scrolling in real time. But at 6.31, we have a definition of discrimination. So Rule 6.31 says a lawyer must not directly or indirectly discriminate against a colleague, employee, client, or any other person. And one of the things that I will do is I'm going to skip over some of the commentary, especially where it's expressing precatory or aspirational language, which is very common with things of this nature. I will address some of the commentary which explains or interprets what's meant by some of the key concepts. So if you have any questions that about the commentary that I've skipped over, please do feel free to ask. And so point one, again, talks about lawyers and their unique role in the administration of justice. So I'm going to skip that. All of you know that you're very important and great, so I don't see any reason to focus on that too much. Commentary number two, very similar, but discusses what a lawyer ought to do in terms of fostering a professional environment which is respectable, accessible, etc. I'm going to jump over that a little bit as well, though we can, as I say, always return to it if you have questions about it. Point three of the commentary is particularly important. And I know that many of you may find yourself outside the Yukon, so some of you may be joining us from, for example, British Columbia or Nunavut or other places. Paragraph three of the commentary, I think, is particularly important, especially from a Yukon perspective, given our history, given the demographics. And it says as follows: Indigenous peoples may experience unique challenges in relation to discrimination and harassment as a result of the history of the colonization of Indigenous peoples in Canada, ongoing repercussions of the colonial legacy, systemic factors, and implicit biases. Lawyers should take particular care to avoid engaging in, allowing, or being willfully blind to accusations which constitute discrimination or any form of harassment against Indigenous peoples. So the first obvious point from that particular section is it does use the word discrimination, and we haven't defined it yet. The commentary will provide you a definition later on, but I think it's an opportune time for me to offer you a definition from human rights law to start there. So where we see the term discrimination and where we see the term harassment, which is also defined in the Yukon Human Rights Act, and the definition is similar, if not identical, to provisions in other jurisdictions defining harassment. So discrimination comes from the Supreme Court of Canada's decision in Moore versus British Columbia, or Moore and British Columbia in 2012. And previous Supreme Court of Canada jurisprudence attempted to define it. It did so successfully, but it did so in a way that wasn't, as previous Supreme Courts were known for doing, getting directly to the point. So the Moore test establishes a three-part test to define discrimination. So the first part is there a characteristic protected by human rights legislation? In the Yukon, there are 14 different protected characteristics. Indigeneity would fall under potentially three. So ethnicity, which is the first, which would include race and color. The second would be ethnic or linguistic background. So the first is ancestry, the second is ethnic or linguistic background, and the third is national origin. The third is particularly interesting and important because they are First Nations. So oftentimes people understand that to mean a nation state. There's nothing in the law which suggests that that is the definition, which should be imported. So First Nations can be captured by national origin. So we have three potential protected characteristics that would satisfy part one of the Moore test. Part two is whether or not there has been an adverse effect or an adverse impact. In the Yukon legislation, it's described as unfavorable treatment. And the third and final part of the Moore test is the protected characteristic a factor in the unfavorable treatment? So in other words, one, is there a protected characteristic? Two, is there unfavorable treatment? Lastly, are one and two connected? That's probably the best way to understand discrimination. The Yukon, in terms of official statistics, 25% of the population identifies as being Indigenous or a member of a First Nation. The numbers might, in reality, be higher than that. And so this particular provision is very important to bear in mind, that there is a unique challenge that Indigenous people face in relation to discrimination and harassment as a result of the colonial legacy. And the commentary is rightfully explaining that members of the profession need to be aware of that to avoid engaging in, allowing, or being willfully blind to actions which may constitute discrimination or harassment. We have a question popping up, so take a look. So I'm going to read the question, and the question reads, thank you so much for holding this session. I had a question about the discrimination provision. Is it implied that discrimination based on a prohibited ground is prohibited, or any kind of discrimination, whether or not it is prohibited by human rights legislation, charter, etc.? So that's the question. To rephrase it, does the discrimination have to engage a prohibited ground or a protected characteristic enumerated in legislation for it to be discriminatory, or can discrimination happen in circumstances where there is no protected characteristic? That's an excellent question for a number of reasons. And I suppose the first obvious point is that there isn't harmonization between human rights statutes in the country. So the Yukon has probably the most extensive number of protected characteristics of any piece of human rights legislation. And I'll give you a quick example of that. So political association activity or belief is protected in Yukon. It isn't protected in a place like Alberta. criminal charges and criminal convictions is drafted more broadly in Yukon than it would be in other jurisdictions where it only applies to those criminal convictions for which a pardon has been issued. And so in terms of the Human Rights Act, there has to be a protected characteristic or a prohibited ground for it to create the basis to file a human rights complaint. So for example, social condition is one that's been debated in the legislature here that has never been adopted. So if somebody were to file a complaint on the basis of social condition, whether that has something to do with financial precarity or credit score, that wouldn't ground a complaint under the Act. But I think what's important to note here is we're discussing the Federation of Law Society of Canada's Model Code. And one of the things that's really interesting about that, and there's a quote in a 2019 decision of the Ontario Superior Court. It was Christian Dentistry and Medical Association and the Ontario College of Physicians and Surgeons. And so the court there, the case basically dealt with refusing to perform a medical procedure because of religious belief. So if you think about things like abortion, in vitro fertilization, those sorts of things, the Ontario College required an effective referral program. And in discussing that, what the court noted is that regulatory bodies, when adopting policies, do not have to go with what the court described as the lowest common denominator to protect the rights of the vulnerable. So while under human rights legislation, it may not found a complaint, it is very possible that either the Yukon Law Society or other law societies which adopt the model code, they may take a broader view of that. In other words, they might consider characteristics which don't find themselves in the various human rights legislations that they find themselves in, but nevertheless, they may opt to adopt a higher or greater or more expansive understanding of discrimination that is where these protected characteristics are non-exhaustive and only illustrative. Does that answer the question? If that answers the question, let me know. If it doesn't, also let me know in the comments section and I'll jump back into it. Wonderful, it looks like it did. So I wanted to say a thing there about the importance of paragraph 3 of the commentary. So because of the unique and horrible experiences of colonialism, the legacy of which is still with us, it is particularly important to take particular care to avoid engaging in certain behaviors. And again, our language is riddled with these sorts of things. I can count, I mean, on both hands, just in the last year alone, whenever I've heard words like, it bothers me to even say it, but let's have a powwow as opposed to a meeting. I mean, this is the sort of thing which would be unacceptable and that members of the profession ought to be aware of, given that unique experience. 4 is a really interesting one. And here it talks about lawyers should be aware that discrimination includes adverse effect and systemic discrimination, which arise from organizational policies, practices, and cultures that create, perpetuate, or unintentionally result in unequal treatment of a person or persons. I'm going to pause there for a minute because those of you not familiar or less familiar with concepts in human rights law might be asking the obvious question here in terms of what is adverse effect discrimination and what is systemic discrimination. And we can have at least half a day discussion about both of these concepts. So I'm going to give this to you in a nutshell, but would welcome questions about this. So adverse effect discrimination is to be contrasted with what's referred to as direct discrimination. So before the Supreme Court of Canada's decision in Moore, the law used to make a distinction between direct discrimination, in other words, where somebody says to somebody else, I'm not giving you a job because of your learning disabilities. It's obvious that the discrimination is intentional, it's direct, and it's obvious. Adverse effect discrimination, which is a second type of discrimination, is where there is a policy or practice which is facially neutral, but has the effect of discriminating. So there's some commentary on the distinction being, on the one hand, intention, which informs how we understand direct discrimination, and the effects, which define and inform the definition of adverse effect discrimination. And there would be different awards and damages. There would be a slightly different test. And so employers would, or organizations, I should say, not simply employers, would often invoke as a quasi-defense adverse effect discrimination as opposed to direct discrimination. The law no longer recognizes the distinction from a legal standpoint. It does recognize that there's a distinction descriptively, but there is no distinction legally. So there won't be a difference or a significant difference in terms of liability. There still might be a slight difference in terms of awards and damages, and there are a number of factors which inform that. But to understand this is just to understand the descriptive difference. One is direct, it may be intentional. The other is facially neutral, but has the effect of discriminating. And human rights law in particular is focused more on effects than intention. Systemic discrimination in particular would involve a lengthy conversation. The Yukon Human Rights Act doesn't define it particularly well. It defines it as something which results in discrimination is itself discrimination, which is probably a better definition of adverse effect discrimination than it is systemic discrimination. The Manitoba Human Rights Code does a better job of attempting to define what systemic discrimination is, and it defines it as a series or a pattern of events that individually may not result in discrimination, but when taken together, may found a complaint of discrimination. And systemic discrimination, I think the best way to think about it is to understand that individual behaviors, of course, can be discriminatory, but discrimination is better understood as a series of systems and the impact that those systems have, particularly for historic reasons, but that are still with us. And these systems produce inequity, it produces bigotry, it produces barriers. And so when we are discussing systemic discrimination, the best way to understand that is that we live in a society with innumerable systems, all of which contribute to what society looks like, and that results in barriers and burdens being imposed on certain groups because they have what human rights law would call protected characteristics, but not only because of that. So in other words, where people find themselves in society is as a result of the construction of these systems and policies, which have resulted in tremendous inequity in society. And the point that paragraph 4 is making, I think here, is that there should be an awareness that discrimination is not simply somebody making an obvious racial slur or bigoted comment that targets somebody's sexual orientation or their disabilities or their gender identities, but it can operate more subtly, as systemic discrimination does. And it's important to think about these things as effects driven, which is the point of adverse effects. And it's also relevant to a discussion of systemic discrimination. So people's circumstances are often the result of systems. Really important to understand, I think, but I could probably discuss this for hours. Lawyers should consider the distinct needs and circumstances of their colleagues, employees, and clients, and should be alert to unconscious biases that may inform these relationships and that serve to perpetuate systemic discrimination and harassment. I think the important thing to note there, and some of you have probably caught it, which is being alert to unconscious bias. So at first glance, you might tell yourself, well, wait, how can you be alert to unconscious bias? If it's unconscious, the moment that you're aware of it, maybe it isn't conscious anymore. And I think at second glance, what this is really saying is that there are certain things that we do for the reasons listed immediately before that sentence that we're not necessarily aware of, but we ought to be aware of how we're conducting ourselves and the impacts that that has. So for instance, someone identifying as a man in a work environment may instinctively look at other men, particularly straight white men, as being the source of power, authority. One might find themselves gravitating towards people in a position of power, and typically that might be straight white male, particularly in a profession such as the legal profession, which often required a lot of wealth to go to law school. And so really important to note of our behaviors and the optics of them, even if we're not aware as to precisely what that might be, and to flag these behaviors as an act of self-reflection. So are we paying attention to the sorts of things that we're doing, who we're talking to, how we conduct ourselves, the vocabulary that we use, might even be in some respects how we dress and expect others to dress. I know that the legal profession was notoriously stuffy in terms of these sorts of things. So it's particularly important that this is noted, because it can be, these can be the results of unconscious biases. And lawyers should guard against any express or implicit assumption that another person's view, skills, capabilities, and contributions are necessarily shaped or constrained by their gender, race, indigeneity, disability, or other personal characteristics. Really important not to attribute it, whether expressly or impliedly, that any of these things are related to a protected characteristic. I think that that's pretty straightforward in terms of how that's described. But I think that that is what Section 4 of the commentary is very importantly trying to stress. So there we have the adverse effect piece, the systemic discrimination piece, which I was very glad to see, and a guarding against things like unconscious bias, implicit assumptions in how we view people from diverse backgrounds and protected classes. And again, I know that that contains a lot. So if you have any questions, let me know. And now we have a definition of discrimination, which is verbose, but does make sense. And I think that what I described in terms of the Moore test, I think you'll find it basically encompasses the commentary in Section 5 in lesser words, maybe not a lot fewer words, but fewer words nevertheless. So here, paragraph 5 is describing discrimination in terms of a distinction, intentional or not, based on grounds related to actual or perceived personal characteristics of an individual or group, which has had the effect of imposing burdens, obligations, or disadvantages on the individual or group that are not imposed on others, or which withhold or limit access to opportunities, benefits, and advantages that are available to other members of society. Very important because here we have, for the first time in the conversation, the actual or perceived personal characteristic. So from a human rights standpoint, this is also true. So someone believing that someone else has a protected characteristic, whether or not they have it in actuality, will not prevent a human rights complaint from being filed on that basis. So classic example might be somebody fires somebody because they think that they're a member of the 2S LGBTQ community, when in fact they're not. The protection operates in the same way. And so the commentary at paragraph 5 discusses this here, which is important. And it's also a discussion that talks about having the effect of imposing burdens, obligations, or disadvantages on individuals or groups that aren't imposed on others, or the withholding or limiting the access of opportunities, benefits, or advantages that are available to others. Here again, what you're seeing is the emphasis on something which is critical to the legal profession, or particularly critical to the legal profession, because I think the pathway to becoming a lawyer 20 or 30 years ago was laden with exactly this. And as we are more aware of these sorts of discussions, it's great that the Federation of Law Society is grounding the discussion along these lines. But these are also concepts known to human rights law. And so we have another question, and I'm going to read this. From my perspective, discrimination in human rights legislation does not reflect the realities of Indigenous communities and viewpoints. Indigenous communities are impacted by decisions made by the non-Indigenous peoples, are imposed on Indigenous communities disproportionately. There's economic discrimination imposed on Indigenous peoples that is for the benefit of non-Indigenous peoples and communities. Wholeheartedly agree. And I speak a lot, in fact, about the problems in particular of human rights legislation, often and fairly endlessly. And I'm happy to have that conversation. And I think if we have time for a discussion at the end of this presentation, we can certainly zero in on that. I think that comment is important. And of course, I agree with that wholeheartedly. And I'd like to thank you for raising it. Undoubtedly true. And, you know, there's an expression that many of you have heard: judicial conservatism is the last thing to change. And so oftentimes the law is the last thing to change to reflect realities elsewhere in society. And so I agree wholeheartedly with that. And so it tells us that we have a lot of work to do to improve the situation of human rights law in particular and other related legislation. And as I say that, a second question that comes in by the same questioner, also wondering about the human rights legislation and how it deals with those Indigenous communities that are supportive of the legislation. There are a number of Yukon First Nations that are not supportive of the legislation since they're self-governing. How is this dealt with or contemplated? I think good question. So, and again, I'll spend a couple of minutes on this, and then if I haven't answered it completely, we can have a discussion about it. But a lot, so Yukon First Nations are under the jurisdiction of the Canadian Human Rights Act, and therefore the Canadian Human Rights Commission, and not the Yukon Human Rights Commission. And so in terms of how that's dealt with, for the most part, our legislation doesn't really deal with Yukon First Nations for that reason, because we don't have jurisdiction over them. So I don't know whether the comment, I take the comment, or the question, I should say, when it refers to the legislation, if it's referring to the Yukon Human Rights Act or the Canadian Human Rights Act. So I'm not entirely sure about how, and Yukon First Nations have a view in terms of the Yukon First Nations Act for that reason. I'm not privy to much of the views outside of what I've heard from colleagues and friends who belong to First Nations about their views of the Canadian Human Rights Act, which I can certainly discuss, but I don't know how much value it would have because it's conversational and anecdotal. But if you want to hear me talk about that, I'm happy to do that anyway. So do let me know if that's the case. So I think at paragraph 5, we have a definition of discrimination. A definition of harassment, which was raised earlier, is addressed in the later provisions. But in the interest of time, I'm just going to move along, and we have 6 that disappears. And so let me just pull up here a version. Do you have the ad written down there, Lesley? Or do you have a paper copy with you? I can pull it up on. No problem. Let me just pull that up here. So we downloaded a PDF version of it, and I have it here. Just bear with me. I'm going to see if I can copy and paste it. Fortunately, the PDF version from the FLSC's website was not PDF friendly, it appears. So here we go. Just going to copy and paste this in the chat section so all of you can see it, and I will also read it. Bear with me here. So I'm going to put this in the chat function. So, and I'm also going to flag that we did receive another question, which is a hello from Nunavut. Hello, Nunavut. Very pleased to be with you this afternoon. Please do share your general views. I'm happy to. I'm just time watching a little bit. I don't want to cut into Lesley's time, and I just do want to get through the rest of these provisions. I think we will have time to discuss it, and I will share my general views at that stage. I hope that's acceptable. I do want to discuss this and don't want to duck it, but I do want to make sure that we cover the model code, since that's the reason why we're here. So let me get through this, and happy to discuss that. So my apologies for not discussing it in the moment, or at the moment, I should say. But just going to go back to read 6 to you, since unfortunately we don't have it on the screen share there. And it says the principles of human rights and workplace health and safety laws and related case law apply to the interpretation of this rule and to Rule 6.3-2 and 6.3-4, which we'll be discussing those rules momentarily. A lawyer has a responsibility to stay apprised of developments in the law pertaining to discrimination and harassment, as what constitutes discrimination, harassment, and protected grounds continue to evolve over time and may vary by jurisdiction. So I think that echoes what I said at the outset, which is some of these concepts are not exclusively the remit of human rights legislation. So the definitions of things like harassment, bullying, reprisals, all of that stuff is found in other bodies of law. This just informs you as practitioners that it is your responsibility to stay updated and apprised, because these concepts change constantly. And that is not simply the enumeration of those concepts, but the interpretation of those concepts. 7, which I'm not going to read in its entirety, but it lists a lot of the behaviors that constitute discrimination. And important to note that this list is not exhaustive and is illustrative only. So I'm just going to jump back in to 7. And so there's a lengthy list of these. For those of you that have read it, and it is quite extensive, I will, there isn't anything here that I see which is particularly complicated, but it's numerated A through L, or sorry, A through M. If you do have any questions about specific behaviors, we can certainly discuss those, but in the interest of time, Section 7 of the commentary is an illustration of the sorts of things that could constitute discrimination or harassment. And lastly, we have 8, which is, it is not discrimination to establish or provide special programs, services, or activities which have the object of ameliorating conditions of disadvantage. And it cuts off, I'll read the rest of it, which is not lengthy. It is not discrimination to establish or provide special programs, services, or activities which have the object of ameliorating conditions of disadvantage for individuals or groups who are disadvantaged for reasons related to any characteristic protected by applicable laws. So that is, one could refer to that variously as the ameliorative programs section or the affirmative action section of the commentary. So in other words, it is not discrimination to, for instance, for a law school to reserve a portion of its seats during the admission process from members of Indigenous or First Nations communities, or for employers to consider equity-seeking groups, which are often defined as in the following way, and it's restrictive, particularly in federal law, but the best way to understand that is equity-seeking groups are those with a protected characteristic. So it can be those with disabilities, it can be racialized folks, it could be Indigenous or First Nations persons, and it could be, it formally and in some places still refers to equity-seeking groups, the last category as women. I think that should be interpreted more broadly as to mean people with various gender identities or gender expressions, which have been historically marginalized, oppressed, etc., or at least that would capture the spirit of the rule. And lastly, lawyers are reminded that the provisions of this rule, this is 9 of the commentary, do not only apply to conduct related to or performed in the lawyer's office or in legal practice. And this aligns very well with human rights legislation. The workplace is not simply the brick and mortars of the office. It's anywhere where employment relationships are live or in play. It could be a Christmas party or a holiday party of some sort. It could be any social event that the workplace puts on. It could be traveling for a conference. But I think lawyers are members of a regulated profession. So I think to understand that more broadly is even when one is off the clock, the things that people do can bring the profession into disrepute, even when it's not remotely connected to employment. So this is particularly important. And I think it illustrates the high expectations that are expected of members of the profession, which are very much in line with the profession. So that is the commentary, and that is Rule 6.3.1. I will note that it is the lengthier from a commentary standpoint part of the rule, so the rest of my time will not nearly take up as much time as I did to explain 6.3.1. And we have a question. Oh, false alarm. We don't have a question. I'm going to move on to discuss 6.3.2, so I'll go back to the screen share so you can see it. And Rule 6.3.2 says, a lawyer must not harass a colleague, employee, client, or any other person. Really important, because now instead of simply couching a definition of harassment in the earlier rule, we have a dedicated section, which is great. So the first paragraph of the commentary says, harassment includes an incident or a series of incidents involving physical, verbal, or nonverbal conduct, including electronic communications, that might reasonably be expected to cause humiliation, offense, or intimidation to the person who is subjected to the conduct. The intent of the lawyer engaging in the conduct is not determinative. It is harassment if the lawyer knew or ought to have known that the conduct would be unwelcome or cause humiliation, offense, or intimidation. Harassment may constitute or be linked to discrimination. So quite a few things to unpack there. And I'm glad to see that this particular section of the commentary is far more plain language than a lot of human rights codes, which defines harassment as a course of vexatious conduct, which one knows or reasonably ought to know will cause. And here we have alignment, so humiliation, offense, etc. And so vexing is appropriately rendered here. So something which is calculated to cause humiliation, offense, or intimidation. And now we have the reasonableness as a standard. So the question isn't what one actually knows, but what one ought reasonably be expected to know, in other words. So whether one actually knows it is less relevant than the fact that this establishes a test of reasonableness. And human rights law does discuss this quite extensively. So, and the rest of this is appropriately defined. Causing humiliation, offense, or intimidation to the person who is subjected to the conduct. Typically, human rights law requires a course of conduct. And a course typically means more than one. But there's a discussion about this in the subsequent paragraphs of the commentary. So we'll discuss what a course of conduct involves in terms of the Human Rights Act. But again, important to know that the Law Society can set different standards. And commentary 2, or section 2 of the commentaries here, gives us a list of behaviors that will constitute harassment. And sorry, quickly before I get to that, Section 1, or paragraph 1 of the commentary the very last sentence says harassment may constitute or be linked to discrimination. So the use of the word may there indicates that it does not have to be here connected to a protected ground or a protected characteristic. So I'm thinking back to the first question that we had, and this is probably the answer to that first question in the code itself, that it doesn't have to be connected to a protected characteristic, or at least that's the implication being made in that last sentence. So now commentary 2, or paragraph 2 of the commentaries, gives us a list of the sorts of behaviors that could include harassment. So I'm not going to read all of these. I'll hover over it for a moment. I'll let all of you read it for those of you that haven't had the benefit of reading this yet. But some of the takeaways here, which are illustrative, they're not exhaustive. All of these are, I think, accurate descriptions of behaviors that would constitute harassment. And this allows me to get into what the courts established for the first time in Jansen and Platy Enterprises, which goes back to 1989. It fashioned a test for the purposes of sexual harassment that has been used later to understand what harassment is, which is not necessarily sexual harassment, but which is connected to harassment, discriminatory harassment, let's call it. And it established an inverse correlation between the numbers of events and the objective seriousness required in those events for a requirement of repetition to be displaced. So in other words, and to put it simply, the law defines these behaviors or places these behaviors on a spectrum of objective seriousness. So jokes in the workplace, for instance, might find themselves on the lower end, as has been traditionally understood anyway, or historically understood. And physical conduct, which may include violence, but doesn't necessarily have to include violence, is at the extreme end of the other spectrum. And so conduct which that the courts have seen to be less objectively serious will require a repetition for it to create liability in terms of harassment, as distinct from discrimination, which is not harassment. And so this is why oftentimes definitions of harassment require a course. And so it's worth thinking about these behaviors to a certain respect in terms of where they might find themselves on that spectrum as to require a course or not. The thing to say about that also is, in a case called Pardo, 2003, emanating from British Columbia, or decided by the British Columbia Human Rights Tribunal, it did acknowledge that even a one-time comment could constitute discriminatory harassment. And the factors to take into account, and I use this as an example because comments were historically understood to be on the least serious spectrum, but a one-time comment could found a complaint of discriminatory harassment, and the tribunal provided a list of factors that one ought to consider. So things like the power imbalance, the virulence of the comment, whether an apology was issued, whether the person on the receiving end of the comment was a member of a protected class or had a protected characteristic, etc. Now, this case was decided in 2003. Since then, we've evolved awfully quickly, and Pardo did not find in that case that the comment it dealt with was discriminatory, and in fact provides an illustration of the sorts of comments which the vast majority of us would find to be atrocious, but in 2003 weren't. So while I'm mentioning there is a spectrum to determine whether or not the requirement that there be a course of conduct is satisfied, and here we have an illustrations of the course of conduct, it's probably best in a practical sense not to look at it that way. It doesn't serve any function for one to say, well, that sexually inappropriate joke was only made once in the office, so I'm going to leave it alone. Action is required. So from a practical standpoint, you can read that out. And again, important to note that the Law Society can adopt more rigorous and robust measures and interpretations of all of these when applying the provisions of the code. Section 3 talks about bullying and cyberbullying. Obviously, that is a form of harassment. It may involve physical, verbal, or nonverbal conduct. It is characterized by conduct that might reasonably be expected to harm or damage the physical or psychological integrity of another person, their reputation, or their property. And then we have, and it gets cut off again, so I'm going to post it in the chat here. It gives you a number of criteria. Bear with me for a moment. You have it there in the chat. Again, nothing particularly complicated or controversial there. So it's in the chat if you'd like to see it. I won't comment too much on that, since I think it's fairly obvious, but happy to take questions on it after. And lastly, and this is the last thing I'll say before turning it over to Lesley, lawyers are reminded that the provisions of this rule do not only apply to conduct related to or performed in the lawyer's office or in legal practice, which echoes exactly what the last rule said, that none of this should be considered as limited to what's happening in the workplace and on the clock alone. Just got a question saying chat is disabled. My apologies. Thanks for that. I'm going to post it in question and answer section, which I believe should be working fine. Thank you for that. One moment. Ah, interesting. Okay. It's not letting me post it in the Q&A session and section either. So I'm going to do a different sort of screen share here. My apologies. So let's turn this off and we will turn it back on. There we go. Hopefully you can see that. Leo, I don't know if the font is equally small there.
It's small, but it's readable. I have a pretty small screen too. I think I'm also going to post the link in the Q&A to the document that you're looking at in case anyone wants to pull it up on a side screen or look at it themselves.
Sure. And with that said, I'm going to stop talking and I'm going to turn it over to Lesley. I apologize that took a little bit longer than I expected, but I'm going to turn it over to you, Lesley. Yep. Oh, yes, with pleasure. Here we go. Oh, sorry.
Thanks. Hello, everybody, and thank you for tuning in. I'm a mobile here, which is unfortunate. I smashed up my knee a couple weeks ago and had surgery, but the vandal in me takes some pleasure from the fact that I get to put my feet up on the Law Society Executive's chair. An opportunity I'll never have again. So thank you very much, Birju, for sort of scoping out the first two sections, first two editions from the model code, because they have a great impact, of course, on 6.3-3, which is the prohibition on sexual harassment. So like Birju, I'm not going to graph through every provision. What I am going to talk about today is what sexual harassment is, why a separate provision respecting sexual harassment was thought to be needed, why lawyers should be concerned about it, the scope of the provision and how it relates perhaps to the statutory obligations in both human rights and workers' safety legislation. And I'm also going to talk about a bit about a lawyer's duty as a, I may say the word bystander, but somebody who is perhaps aware of harassment, and the issue of consent, which really weaves its way through matters dealing with sexual harassment, perhaps to a greater extent than on a practical basis than other types of discriminatory harassment. So you can see when Birju went through the first two provisions of the code, he went from discrimination to harassment, which is not always, but is often discriminatory in nature. And sexual harassment is a particular type of discriminatory harassment. The characteristics are the same as those set out in 6.3-2, and to some extent differ from the human rights code provisions in respect of harassment set out at section 14, as Birju pointed out, in that while they do refer to unwanted, unwelcome incidents that include sexual advances or otherwise unwanted incidents that are based on the subject's gender identity and expression or sexual orientation, and that have an intent to demean, to diminish, to be disrespectful, to undermine. So the scope of that type of harassment is stated a bit differently than the human rights legislation is. The code refers to gender identity and expression, or sexual orientation, while human rights case law has found that sexual harassment of a discriminatory nature is based on sex, including pregnancy, which is the biological or natal determinant, gender identity or gender expression, which is as set out in the code provisions here, sexual orientation, which is in the code provisions, and also in some cases, there have been some cases which have found family status relating to, all the case law has been in respect of motherhood, actually, but that has found to be a trigger or an identifier for discriminatory harassment. I take the code provisions which say gender expression, and identity or sexual orientation as basically as gender being synonymous with the concept of natal sex. I wanted to take a minute to say, because I often get a question or tripped up on this, sexual harassment is not limited at all to men harassing women. Any person, any gender expression or identity, any sexual orientation can harass any other person. And the code, of course, prohibits sexual harassment by a lawyer. I will say, however, that the great majority of cases are men harassing women, followed by men harassing other men. And that is, I believe, a function of who has power in our society. Harassment, sexual harassment is very much a power flex. I'm just going to digress a second to underline that because I think it's important, particularly in the employment sphere, where there is often that imbalance between lawyers who are employers and support staff or junior lawyers in that respect. In one of the first major cases dealing with workplace sexual harassment, Jansen versus Platty, a 1989 case, 1989 case from the Supreme Court of Canada, then Chief Justice Dixon quoted a very famous article on the new topic then of workplace sexual harassment by Professor Agarwal. Whether it's from supervisors, co-workers, or customers, sexual harassment is an attempt to assert power over another person. And sexual harassment is any sexually oriented practice that endangers an individual's continued employment, negatively affects his/her work performance, or undermines his/her sense of personal dignity. And that case is still quoted with approval consistently in human rights decisions in respect of workplace sexual harassment. So let me take a step back from that, step out to talk about what workplace sexual harassment is. Paragraph 2 of the commentary provides several examples of harassing behavior, which go beyond what is thought of as the traditional groping or fondling, the clear sexual harassment. As Birju says, these examples are illustrative, not exhaustive, and they include displaying sexualized or other demeaning images. And this would include sexualized posters and pornography. And you know what? I've been a lawyer in the Yukon for 38 years. And really, when I started out, it was not uncommon to see posters ripped from magazines, etc., with highly sexualized pictures. I mean, we're not talking classic art reproduction. And, it was part of the tenor of the times, but it's very clear that it would not be acceptable now. And certainly the exchange without willingness of pornography is going to be harassment. It also identifies as harassment, sexualized speech, including jokes, innuendos, gender-based comments, gendered vulgar nicknames, inquiries or discussions about sex. This would cover, as I said, gendered vulgarities. I think it would also cover things such as refusal to use a person's identified pronouns, telling vulgar jokes, riddles, witticisms, and of course, an insistence upon talking about sex. And the commentary clearly does cover unwanted physical touching, sexual violence, as well as unwanted flirting, sexual advances, and propositions. So, as I said, these are illustrative, they're not exhaustive. And even though they're pretty broad, those paragraph 2 of the commentary examples. And I think the broad scope is required because people consistently find ways to sexually harass that make you question, that where you have to interrogate the situation and the characteristics of people who are involved in it to determine whether a particular use of power over somebody else is or is not sexual harassment. One lawyer in Whitehorse told me that when they went for an articling interview outside, the two partners that interviewed them took out a piece of floorboard, put it down, and then made that prospective articling student walk across it in front of them back and forth several times so they could test whether the walking in heels would be disturbing to them, too distracting. The prospective lawyer was so taken aback by the request that they did it. They just did it automatically. And that's really one of the things about responses to workplace sexual harassment. People can be so surprised that how it's presenting itself that they don't deal with it at the time. Anyway, that prospective lawyer walked back and forth several times in the moment, becoming aware that, you know what, this was not for any job-related intention. They could simply have told me to wear quiet shoes if noise was the concern. This is harassment. This is an attempt to get me to show off my body, walking back and forth. But they wanted the job, and they did it, and they didn't say anything about it, and they took the job. I think that example would probably fall under the commentary examples, paragraph 2D and perhaps E. Another lawyer told me that when they articled at their firm, when there would be a round table every week when everybody went through their cases, if the lawyer on the other side was a woman, there would be a kind of separate or simultaneous round table where the lawyers would say whether they would want to have sex with that lawyer on the opposing side or not. There were two women lawyers at the table, a junior lawyer and one student. And when it came to them around the table, they'd be asked, Do you want to comment on it? Or do you want to skip the question? And if they skip, the survey would go around. And I think commentary paragraphs 2, D, E, F, and G would speak to that. It should be noted that the harassment provisions speak to electronic technology. That's important because technology does keep up, or harassment does keep up with technology. I don't know if people are aware of the situation of Jeffrey Toobin, who was the senior legal correspondent for the New York Times and for CNN, and was caught masturbating during a Zoom conference call. Several junior staffers noticed it more immediately, perhaps, but were afraid to call it out. It took another senior writer, Masha Gessen, to identify and say, "Hey, stop that now. We know what you're doing." The New Yorker did have an inquiry into it. They did an investigation, and they ended up severing him as their senior legal critic. But the CNN took him back after several months. And of course, several months ago, so a couple of years ago now in 2021, a member of Parliament, William Amos, exposed himself twice over during a Zoom committee meeting. First time saying it was an accident, the second time saying it was another accident, but he was taking time off to work on his wellness. He chose not to run. Now, there are questions, of course, about was this actually an intentional act of harassment, or was this a function of illness in that case? It doesn't really matter. The people who were subject to it were being harassed. And for those who were not committee members themselves, but were juniors, etc., it was a situation where it's difficult for them to say something about it. And I just want to say, my favorite example of technology keeping up with harassment is, doesn't relate to the legal profession, but I was told in Yukon by a young woman who told me that I could use this example, that she went into town from her workplace, went into a bigger center, and bought some goods for one of her colleagues who was senior to her. She cost $60. She came back and said, okay, here it is at $60. He said, great, I'll send you an electronic transfer. She wasn't set up for automatic deposit. So he sent her the security question and the required response. And it was, do you think colleague's name is hot? And the response had to be, yes, I think colleague's name is super hot. And frustrated, she wanted her money. When she went to talk to him about that, he was out of town he was out of camp at the moment. She did it. She said she sent that security, she answered the security question, but as she explained, she still felt demeaned and disrespected, even in the telling of it. So those examples of harassment can cover a wide gamut and are not limited. But why does workplace sexual harassment deserve its own provision while other forms of discriminatory harassment don't? One big reason is because it's still out there to a great extent, and it's still out there in the legal profession. A 2018 Stats Canada a survey of provinces, 32% of women reported that they'd been experienced some form of sexual harassment in their workplace. 17% of men reported that they'd been harassed. A 2018 International Bar Association survey, 135 countries, 7,000 correspondents, found that 50% of women in the legal profession reported sexual harassment or bullying in the workplace. And unfortunately, Canada had among the highest percentage of incidents reported. Now, that could be a function of who is answering the survey, but it's not good and it's not nice. The law societies of Ontario, Alberta, Saskatchewan, and Manitoba have all put out articling, surveys, and in them, it's usually between 20 and 32% have said, yes, I was harassed. They didn't clarify what type of discrimination that they were harassed in respect of in the question. But in the sort of anecdotal answers that people sent in, it was clear that workplace sexual harassment was an issue for them. And you only have to look at the number. If you look through other jurisdictions' discipline reports, that it's a steady 20% of the cases have to do with sexual harassment, divided about roughly 50-50 between harassment of clients and harassment of staff. At the workplace sexual harassment clinic, I haven't had anybody coming to me talking about lawyers. I believe when I was at the Human Rights Commission, the history was no complaints had been brought about lawyers. But I have had 3 people tell me, not sort of bringing a complaint, but informally tell me that they were about incidents of harassment in the Yukon. All 3 of them were staff. All 3 of them were harassed by senior lawyers. None of them were in ongoing relationships where consent could be an issue. And all 3 of them did give me permission to talk about it. One told me, one was a summer student. They just walked out. They were sexually importuned by a lawyer. They just left that day, went back to school. Another told me that they didn't say a word, but they stayed working there for several months. They needed the job. And one person told me that they did go and complain right away. And the firm that they were working at had an investigation. And the results of that investigation were communicated clearly to them. They were happy with the results of it. They were extremely impressed with the way it was carried out and with the lawyer that did it. And they continued working there for quite a period of time afterwards, which is really underlines the value in having a good process to deal with it. So unfortunately, workplace sexual harassment and sexual harassment in general takes place within the legal profession and has taken place in the profession in the Yukon. Another reason it may have its own provision is because it's not always taken seriously by people. It can be minimized as a compliment, a statement in respect of physical appearance or body. Well, that can be described as a compliment or something romantic. Sexual vulgarities are dismissed as jokes, and the sharing of jokes, pictures, videos are sometimes dismissed as part of the bonding exercise in high-stress workplaces. Code provision 6.3-3 and the accompanying commentary makes it clear that all of these incidents, when uninvited, when unwelcome, are harassment. And one of the important things to keep your mind on is that actually consent is an issue, because many of the representations of what might be harassment are not harassing if they're done with consent. A workplace may have a standard in respect of vulgarity to which everybody is agreeable. People can have consensual relationships in the workplace, not with clients, however, even if, like the BC lawyer, you get them to sign a change of solicitor form right outside the courtroom door. But the thing is, the onus is upon the person with the behavior to demonstrate that there was consent, and silence, as we've heard so many times, doesn't equal consent. People have many reasons for not talking about it or not entering into it. And really, this is a situation, if behavior could reasonably be seen to be harassing, unless there is clear consent, it will be harassment. In code,
Lesley, we have a
Sorry.
question that came in a couple minutes ago when you were talking about the Yukon situation. I'll read it out if you.
Oh, thank you.
Sure. So it says, To what extent do you suppose that the lack of reporting in relation to lawyers has to do with perceived power or authority of lawyers in Yukon?
Oh, absolutely. I think it is. The three examples that I spoke about were all support staff and senior lawyers. And the fact is that senior lawyers are often in control of junior lawyers and support staffs, their ability to make a living, their ability to have opportunities in the workplace. In respect of sexual harassment of clients, the discipline reports have been clear that there's a power imbalance there. The client needs something, they need support and they need help. And if there's a chance that they might not get it, that power, you can say, well, they have the power to discharge their lawyer, but depending upon where they are in the legal process and what their situation is, that isn't clear cut at all. And there's a complaints anyway, and sexual assault and stalking charges against a very prominent Ottawa lawyer right now, who basically, sort of said, I will work for you for free in respect for sexual favors. And this person, the person they sent it to, actually in their responses said, well, there seems to be a bit of an imbalance here. and preserve that in text messages back and forth. But I think sexual harassment is almost always, I would say always, an exercise in that power dynamic. And that's why people don't complain. Also, lawyers have traditionally had a lot of clout in the community. Who will be believed? A lawyer or the complainant, particularly in cases where there may have been a consensual relationship that ended earlier, in cases where an employment relationship didn't end well. I was told by one of the people who say, like, who are they going to believe, me or the lawyer in that respect? So I think it's very clear. I know there's only 8 minutes, so I will say the commentary also sets out the scope of the application of the provision in an employment context, and really it's the full scope of the employment context, from the potential for hiring someone, interviewing them, to hiring, benefits, remuneration, allocation of work, which is a supremely important thing for a young lawyer, and also the ability to carry on your work without working in a hostile or intimidating work environment. As Birju said, that behavior need not take place in the workplace as long as the possibility of the impact resonating in the workplace, it is there. I don't think the code provisions, the examples, are quite as clear as to harassment in respect of a client, although it is clear that if it's a strict quid pro quo and submission to unsolicited advances is one of the conditions for the provision of legal service, clearly that is harassment. And also when a lawyer makes a sexual solicitation to someone whom they might confer or deny a benefit upon, that is harassment as well. So that really includes the person who asks you for a recommendation for law school, for example, and things like that. So the intent, and as Birju said, this is a disciplinary code, and the Law Society has the ability to take a broader view of it. It doesn't have to be tied down to the sort of the human rights standard or in that respect. I wanted to note that there's not an explicit duty upon lawyers to report another lawyer's conduct unless we think it would fall within, 7.1-3 on the duty to report. And I'm going to say, I don't think it's crystal clear that it does. Really, I think it could fall under subprovisions E and F of that, but particularly if a client's being harassed. But however, if if the lawyer is not themselves the subject of the harassment, I think it's something, reporting is something that they have to interrogate themselves about as well. And they should certainly speak to the person who is being harassed, because the impact of reporting without their consent to it may be more severe upon the person than the impact of the harassment themselves. And that's a very unfortunate thing. So a lawyer has to take a lot of things into account when they're making the, when they're deciding whether to complain, i.e. what's the impact on the person who's being targeted? Is it possible that this harassment goes further? Whether there are more targets there. So it's not clear, and it requires a lot of consideration, but there is a positive duty on the lawyer under the code provisions not to turn a blind eye to harassment. And that's what people often do. They say, well, it's not really any of my business, or you know what, it could have been a joke and I just took it at that. There is a clear duty upon the lawyer not to do that. But even if a lawyer doesn't report, there's still things that they can do to support themselves and the subject. They can intervene indirectly by saying, if they're in a position of power and feel it's safe, hey, stop that. They can do it indirectly by saying, oh, by getting in between the harasser and the subject, they can tell the subject of the harassment that they know that they've seen it, that they can validate their concerns, that they will support them if they decide to complain, and they can document it, because that third-party support is a very important. So I just want to quickly go on to provision 6.3-4, reprisal, which is a very particular type of retaliation. And in this context, it's punishing a person for inquiring after or pressing their rights, basically being a witness in it. It is an offense under the worker safety regulations and under the Human Rights Act in the Yukon. So Birju and I had a talk last week about the fact that Yukon's human rights legislation is kind of anomalous in making it an offense. And going back over it, I think that's partly because at the time it was drafted, there was still human rights cases still spoke to the need for intention in terms of reprisal. And I think that that's reflective in the fact that reprisal is an offense. That has changed in human rights case law, and I don't think that would be found to be the case anymore. But 6.3-4 clearly prohibits a lawyer engaging in or participating in reprisal against an employee, a client, or any person. And not just the person, obviously, who has complained about discrimination or harassment, but someone who's asked about their rights, who's witnessed it taking place, etc. So it also goes on, commentary provisions 1A, B, D, E, outline examples of employment related reprisal, classic terminating a person, but as I said before, allocating better work, because a loss of interest in work is extremely demoralizing. Refusing to employ someone, so that takes place right at the start. Those people who are applying for articling positions, using it to change a person's terms and conditions of work. Doing so can have a clear impact upon a person's ability to earn remuneration, or prove to the firm that they have value, which is a really important thing. And if your good work, if your money-making work is siphoned off, you're sometimes in a position where you're not valued by the firm anymore. Last thing I'll say, just like in other human rights law, those acts of reprisal do not have to be wholly motivated or solely motivated by retaliation. It just has to be, as in Part 3 of the Moore test, it just has to be one of the reasons. So it may be very valid that, okay, the firm cannot afford this person anymore. This person is struggling with what they're doing, etc. But if one of the reasons is because they have pressed their rights, then that is an act of retaliation. And commentary provision 1.c does give example of intimidating, retaliating against, or coercing other people. Once again, showing that the scope is broad. There are definite ways that retaliation against, for example, clients can take place. A person's reputation can be damaged. There can be gossip or smeared. They can be in a situation where they can no longer find a lawyer. And of course, they can be physically threatened or punished. All these things fall under the scope of this provision. My last note was, if there's time, discussion with Birju about retaliation as an offense. There is no time for that. Sorry, I've rattled through very quickly. If there's any questions at the very end, be pleased to take them, but
very quickly, and I've been trying to do this. Me again. I promised I would stop talking, and here I am subjecting you to more of me, unfortunately. I was attempting to answer that question from, I believe it was Nalini in Nunavut. And I didn't want to duck, which asked about some of the problems with human rights law in Yukon as it pertains to Indigenous people. I typed it up and my laptop shut down twice. So here's what I'd like to do, because I think we're going to run out of runway to answer it. Leo, if I sent you an email with some bullet points, because it is an expansive answer, would you be able to send it to registrants who would be interested? I'm getting a thumbs up from Lynn.
Yes, I would just be going to Lynn anyway, so that's good. You're getting it directly from.
Fair enough. Cutting out the middle person. Yeah. So to those of you who were interested in that question, I apologize that we ran out of time, but I will put something together and already have in the time that we've been here, and I'll send it out. And then if you have follow-ups, please reach out to us at the commission. Back over to Lesley. There you go.
Yes, and I'll just say, I'd just like to reiterate what Leo said at the start, that there is a free and confidential legal clinic for people who maybe just have questions about workplace sexual harassment. Is this the situation? Is this the, what can I do to avoid, like, are there steps I can take if I'm an employer? Is this workplace sexual harassment? Is this just a bad workplace relationship that doesn't fall under the legislation or the code of conduct or anything like that at all? Because that can also be the case as well. But and we provide legal advice. We don't provide direct representation for clients. So if somebody is in a situation where we can be of help to them, the Law Society has our contact information, or you can just simply Google Yukon Workplace Sexual Harassment Legal Clinic, which is a clinic under legal aid. So thanks, everybody. I could talk about this for ages, and the story's compelling but horrifying. So thank you very much. It's been a pleasure today.
All right. Thank you both, Lesley and Birju. And thank you to everyone who submitted questions and comments. It was a good discussion. I wish we had more time. There was a comment from Marlene that we should be offering this annually or biannually, and we'll definitely take that into consideration. I know just from our brief session here that there's a lot more that we could touch on. So thank you all for your attention. There is another CPD coming up later this month on construction law. Please do check out the notice and sign up if that's in your area of interest or practice. And again, thank you to the speakers. And until next time, thank you, Merci Joe, and have a great afternoon.